I'm Jay Metter, CFP, Chris Peterson, my friend and attorney. And right now what we're going to be talking about is trust, which is number 6 in terms of the estate planning things. So anyway, so tell us a little bit about trust, Chris.
Okay. So what a trust is it's a legal entity that exists outside of the maker of the trust. And in that trust, it holds assets, whatever is put into the trust, it holds those assets. And the maker of the trust appoints someone to manage those assets for them. And so that's essentially what a trust does, is it holds assets and it manages and appoints a person to manage those assets.
Well, talk to us a little bit about some of the terminology that we find in trust.
Okay. So typically, what you're going to see first is the first office is the grantor or settlor or trustor. And those are all interchangeable terms, but it's the person that actually makes the trust. It's the person that writes and signs the trust. Then what you'll see is the trustee. The trustee is the person that is appointed to manage and hold the property of the trust. So they're in operational control of the trust. You'll typically see a beneficiary, and that is whoever the trust benefits at the end. So that, in a typical situation, if a husband and wife make a trust, you might see their children as the beneficiary of the trust. Typically, you'll see a successor trustee. So if we talked before about the basketball team and they've got some kids on the bench, well, you do the same thing in a trust. You have somebody on the bench, so that is the backup to the trustee. So the successor trustee takes over for the trustee and becomes the trustee if the originally appointed trustee dies or resigns or becomes incompetent or incapacitated in some way. And then just like what we see in a will, we typically see a remainder beneficiary. And so at some point the trust is going to terminate, and when that trust terminates, whatever is left in that trust, whatever assets are left in that trust, are going to go to whoever that remainder beneficiary is.
I see. So the question becomes, why does anybody even use a trust?
Okay, so there are quite a few reasons that you might use a trust. Number one is it does give you management and control. So and you're going to be able to extend that control over a long term, because a trust can exist after your death. So if you want to manage your assets or have a plan for management or control of your assets after your death, a trust can do that for a long period of time. It can also manage your assets while you're still living. So you might have a trust that's for your benefit, and during your lifetime, that trust will be in existence, and the assets inside that trust will be managed for your benefit. Trusts typically contain what's called a spendthrift provision. So most trusts are creditor protected. So if you were to get a judgment against you, the trust itself would say that no distribution can be made from the trust for the benefit of your creditor. So essentially you're protecting those trust assets from any creditor. Or if you had a trust for the benefit of your children after you passed away, that the trust assets, whatever in the trust, would be protected from their creditors. Now that could be a creditor from a credit card company that they didn't pay. It could be a divorcing spouse situation where the divorced spouse of your child could become a creditor of your child, but they couldn't get into the trust estate. So there's a lot of ways that can occur. One thing about trusts is trusts are essentially operating under contract law, so they avoid probate. So a lot of times we use trust to avoid the probate process entirely. Trusts also have some interesting abilities as far as minimizing taxes. You can have what's called split interest trusts that you can use for getting discounts for estate and gift taxes. When you get into split interest trusts, that's the time you pick up the phone and call the
No.
estate planning attorney.
Well, anytime I'm talking about trust in general, I'm talking to the attorney, so yes. So how long does a trust usually last?
A trust is generally going to last whatever term is set out in the trust. So typically what you'll see in the trust is it'll have a definitive time period. So it might be a trust that lasts for your lifetime, or it might be a trust that lasts for the first 35 years of your child's life. And whenever that term ends, the trust terminates, and whatever's left in that trust gets distributed out to the remainder beneficiary. Now, there's also sort of a maximum duration that a trust can last, and this is known as the rule against perpetuities. There's a few states that have abolished the rule against perpetuities. Texas is not one of them.
Yeah. Oh, well, too bad, gang.
Yeah. So the thing about rule against perpetuities is you need to generally know how it works, but I'll be real frank with you. This is about a month of law school, and so it's really difficult to really understand the total scope of rule against perpetuities. But the shorthand is, if somebody is living and they make a trust and say that at the time that they make a trust, they have 2 kids and they have 3 grandkids that are living, the maximum duration of the trust is however long their oldest living grandchild lives, plus 21 years. That's going to be the maximum duration that the trust can last. So that's what the rule against perpetuities are. And it's goofy. They're trying to, there's kind of a movement nationally to get rid of the rule against perpetuities and go to a uniform standard maximum duration of trust. And if that occurs, the current uniform standard is that a trust can last no longer than 90 years. So hopefully that will pass, and then we can spend 15 minutes talking about it at law school instead of a month.